Lordship, I beg to mention one unlisted matter, Lordship. That is, Lordship, WPC 5 of 2020.
What is the urgency?
Lordship, by the order dated 1st August 2022, your Lordship was pleased to grant liberty to the parties if there is any development, because this matter is connected matter is pending before the Honorable Supreme Court.
Okay.
So if there is any significant development, the parties were granted liberty to make mention.
Okay.
So accordingly, Lordship,
Let it come up tomorrow.
Lordship, if it's possible.
Why?
Not tomorrow.
What is the
Urgent tomorrow, otherwise
Alright.
this matter can
What's
come
the
on
matter
next
about?
week also.
Tomorrow, Lordship.
what's the subject matter?
Subject matter is a remission of sentence, Lordship.
My lord, there was an
Or that
application for remission.
Nawab Thai?
Yes,
Yes, my
Lordship.
lord.
Yes, Lordship.
Okay. Okay.
But so far as my information is concerned, the matter is still pending, my lord.
Yes, Lordship. I'll place every the order date 25 July of 2023, passed by the Honorable Supreme Court. Lordship, I will place, Lordship.
So tomorrow.
Tomorrow, all right, Lordship. All right.
Lordship, I beg to mention item number 6.
You are for?
I'm from respondent number 2 and 3 on behalf of my senior counsel S. General.
I'm appearing on behalf of the petitioner, Your Lordship. On behalf of the petitioner.
Any objection?
No.
Item numbers.
Petitioner number, respondent number 1 and 2 has sought for accommodation on grounds of personal difficulty of the conducting counsel. The prayer is not objected to by petitioner. The same is allowed. This is matter after 2 weeks.
Much about you.
Your Lordship, I beg to mention item number 3.
2017 matter.
But we have already filed the affidavit, Your Lordship.
What remains here? What is required here?
Lordship, the earlier submissions that they made was that they file an RTI and then they'll file an affidavit. I received a copy of the affidavit yesterday. There's a small query, Lordship, regarding the senior lecturer. Because the basic challenge is that it's against a Garo lecturer post.
Oh, okay. That selection board.
Yes, selection process.
Selection process.
They participated in the selection process. Now they've been declared unsuccessful. Now they've come and challenged. But there are many.
I think the grievance is mostly against the member of the interview board, isn't it? Not being qualified as a Garo expert or whatever.
Is the learned counsel?
It's 2017 matter. We cannot just.
Your Lordship, the learned counsel for the petitioner is not well.
We'll take it up on Monday.
So we'll take it after 2 weeks, Your Lordship.
That's too long. Fix it on
1 week. And you see, there are, I think, many counsel appearing for the petitioner. If one is not free, then the other should be.
Yes. Next Thursday, not Friday, Thursday.
Next Thursday.
Okay, Your Lordship.
Positively.
That we cannot say.
Oh, sorry. Thursday. Thursday is 28th.
No, this is the September. This
Oh, sorry, Rosh.
No, today is, yes.
24th.
31st, Lordship. It's not a holiday. 31st.
You're looking at that calendar. Accommodation has been sought for in this matter on behalf of the petitioner on the ground that the conducting counsel, who is the conducting?
SDEP.
Mr. SDEP is not well. is not well. The learned counsel for the learned counsels for the respondents has, however, raised an objection on the ground that the matter has been pending for a number of years. However, since adjournment has been sought for on ground of personal difficulty, this court is inclined to allow the said prayer. However, it is made clear that the matter will be heard positively on the next date. As prayed for, this is matter on 31st.
May it please Your Lordship, I beg to mention item number 1 from the supplementary list.
This matter has not been heard.
No, Lordship.
Who's for the respondent? You are for the
Yes,
respondent?
Lordship.
How many respondents are
I am for 2, Lordship.
and who?
Today I am appearing for 1 and 2 both, Lordship.
You are for 1 and 2.
Yes, Lordship. For today.
So when do we have it?
After 3 weeks, Your
Why
Lordship.
2 weeks?
As the conducting counsel is not well, my lord.
I mean, he's not well now. He'll not be well after 3 weeks. Come up with a better excuse. 2 weeks. On premade by the petitioner, seeking adjournment on ground of on the ground that the learned senior counsel, that the learned DSGI, who is conducting this matter, is not well, and the same not be objected to by the respondent. Matter is adjourned. This is seen after 2 weeks.
Similar prayer for item number 14 to 17th, my lord.
Lordship, in this what had happened, by the order dated 2/8/2023, my lord directed us to complete the respond number 3 as a party, Lordship. Respond number 3. We have filed the application when the matter was transferred to the.
Just a moment.
My lord, kindly come to order dated 2/8/2023, Lordship.
You are talking about item number 14?
14 till 17, my lord, similar matter, my lord.
Okay, you have to complete the accused number 3.
Lordship,
Have you done so?
we already filed the application, my lord, but order to that effect has not been passed, Lordship. On before the Archival court, my lord. We already filed the
Then
application.
let the matter come up. We'll take it up. If it's only for that, then
Only for that, Lordship.
if it is not for effective hearing, then we'll
Copy has been served. We have not seen. My lord,
so we'll let the matter come up. Not at this, not at the mentioned stage.
Much obliged, lordship.
May I please, Your Lordship? My lord, I beg to mention item number 10, my lord, of a daily hearing list, my lord. My lord, this matter was assigned to Additional Advocate General Mr. B. Bhattacharjee, my lord. So we are yet to reassign, my lord, this matter. So, my lord, I'm praying for a short time only, as per the convenience of this court, but not today, my lord.
What's this matter about?
My lord, this is with regard to recruitment of LDA, my lord, in William Nagar. So there was a result declared in Facebook, by virtue of which the petitioner has come and said they have been selected, but we have filed to the extent that we have filed an FIR that was a fake. A proper result was declared subsequently, in which they were not selected, my lord.
As far as the FIR is concerned,
My lord,
what is the status of the
lord,
investigation?
My lord, so far as through telephonic conversation, I have been informed that FIR has been submitted. So, my lord,
FIR.
FIR has been submitted, my lord.
Then there's no.
No, my lord, because the entire thing, what happened here is that since everything was through electronic media, my lord, so social media, my lord, so maybe there was no further witnesses and couldn't be found.
Anyway, the
But
fact,
FIR was
the
listed.
fact remains that if the authority supposed to have issued such a communication or notification has denied issuing the same, then practically there's no case.
My lord,
Anyway, we'll look into it. So how long?
My lord, not today, my lord, because since the situation is such that as per the confidence of this court, any date, my lord. After a week or two, my lord.
1 week?
Your Lordship, I'm for the private respondent.
The selected candidates, my lord.
No, what is the then?
My lord, the
how far is
appointment,
the selection
my lord,
process?
the interesting part is that they have come after the appointment were also given. They have also joined as respect. It's been 2 years now. They have already.
Oh, then
So, my lord, that is the present status of the case. They have already joined.
on permit by the parties, by the state respondent. This is matter of the 2 weeks.
I'm grateful, Lord.
On supplementary cost list, item number 1.
Betul apaan po naman eh? One apaan po?
On daily cost list, item number 1.
May it please your Lordship?
Yes. Tell me.
Lordship, the information I've received from the public prosecutor is that the case has not yet been committed to the competent court, that is the Sessions Court, Lordship.
Lordship, there are 2 accused inside the jail and 2 accused are
Outside the
outside the jail, Lordship. Now because they obtained bail long back, now so far as all the information I have received from them, they have received the summon, the other accused. The next date is 9th of October for supplying the coffees, Lordship. So my lord, as per the last lordship order, my lord, that is at page 15. Para 30, lordship.
Oh, okay. We are on the delay of the trial.
Yes, lordship.
Pokso matter?
No, lordship. The 395, lordship. Not lordship. At this stage, only the condition my lord can put is the condition to secure my attendance to cooperate with the trial, lordship.
Yes, of course. If charge sheet has been filed, what remains?
Your Lordship, but nevertheless, I still have to place forth before this honorable court, because this is the 3rd time they have come before this honorable court for the same accused person. This is the 2nd case that has been charge sheeted against this accused person with regard to the same issue, kidnapping, dacoity, Lordship. I'm just making a note to this honorable court that he is a habitual offender, Lordship.
Until and unless he has been convicted, you cannot say so.
True, Lordship, true.
Okay,
But nevertheless,
that privilege is given to a citizen.
Lordship.
And why do we stress on the due process,
Lordship,
and also the procedures to be complied with? And that is as far as criminal jurisprudence is concerned.
Lordship.
Those are cardinal principles.
Lordship, I'm just placing my submission on the basis of paragraph 13 because the consideration is such, Lordship.
The observation has been made by the court. No objection has been made to it, nor an appeal has been filed against it. So it remains. And the court is bound by the observation.
Lordship, I will not say there is no objection. I'm just whatever the court decides, Lordship.
The court has already decided.
Lordship, actually, but to put it as no objection, Lordship.
No, at the relevant point of time.
Or that point of time, Lordship.
In any case, even if a person is out on bail,
Lordship.
Number one, if he violates the bail condition,
Lordship.
Bail is likely, in fact, automatically cancelled.
Obviously.
Number two, if he is found to be involved in some other cases, there too, the investigation or the investigative agency can take their own
Lordship.
course of action.
At this juncture, I agree with my friend when he says that strict conditions should be laid down, Lordship.
Strict condition.
Lordship.
What Mr. Sheikh, the counsel for the petitioner, who has submitted that as far as the Miss NG Shila, senior GA, who has submitted that as far as the status of the case is concerned, case in question is concerned, the stage is only at the filing of charge sheet, and the matter has not yet been committed to the Sessions Court by the Magisterial Court, since Sessions tribal sections are involved. Now, from this, it could be presumed that the actual trial has not yet commenced. As far as the petitioner is concerned, the learned counsel, Mr. S. A. Sheikh, has led this court to the order dated 12/7/2023, passed by this court in BA number 16 of 2023, involving the same petitioner hearing, wherein in the said order, while declining to enlarge the petitioner therein, who is also the petitioner herein, on bail, an observation has been made by this court that High Court, if no evidence is recorded within 1 month from today, the accused person in question is at liberty to approach a competent court or even this court for grant of bail. The admitted position, as indicated above, is that evidence has not yet been recorded. Therefore, this court, being bound by its own order, would be compelled to allow the prayer made in this petition. Accordingly, the petitioner, is it the petitioner himself or
father of the petitioner? Yes, Lordship.
Accordingly, the accused person. Oh,
The petitioner is the father.
the petitioner is the father.
Father, yes, Lordship.
Have changed to and what's the name of the accused person?
Waliul Islam, Lordship. That is in the cause title, Lordship. Page 4, Lordship.
Oh, that one has changed to accordingly, who knows? Why Waliul Islam, son of the petitioner hearing, is hereby enlarged on bail on the following condition: that he shall not scorn or tamper with the or threaten the witnesses, that he shall not leave the jurisdiction of the state without prior permission of the court, that he shall furnish a personal bond of is 1 lakh with one surety of like amount to the satisfaction of the trial court, and that he shall appear before the court as and when the matter is fixed for the same. Any more conditions?
My lord,
As your lordship pleases.
I have to oppose.
I would love more, but as your lordship pleases.
my lord, since the
Some
regular
of these bail conditions, you go through, or not by this court, but
Lordship.
elsewhere. Some of them are being, what should I say, ridiculed.
Exactly, lordship. Yes.
My lord, since the regular case is not registered, lordship, because the case is not committed, so no regular case number has been given. So if my lord, if any my lord, that police case number is mentioned,
That will be mentioned.
yes, lordship.
That will be mentioned.
That
In any case, I think the stages are at supply of copies.
yes, lordship.
If you have not received, you go to the court, get a copy, and the matter will be speeded.
Next
Will
day
be
is
speed
for
up, I mean.
supplying copies on 9th of October,
Or
lordship.
they have already supplied.
No, lordship.
Not yet,
Because
lordship.
yet 9th of next day is 9th of October.
You do it. Petition dispose of, no cost.
Much obliged, lordship.
Item number 2.
Yes, please, my lord. As your lordships recall, my lord, the arguments are concluded in this matter. Like your lordships have directed the parties to file the relevant documents substantiating the claims. No, my lord, I won't be filing any application. I'll be relying on the documents placed before your lordships. My lord, today I'll be filing my bullet points, my lord, on my arguments.
So you have been heard in this matter?
My lord, yes. On the last occasion. All the parties was
Just refresh this code words.
This matter is relating to, my lord, the managing committee of the Madrasa Himayatul Islam School, my lord, which is, my lord, at Garikhana. My lord. That matter, my lord. My lord, here the Garikhana Masjid Committee, my lord, wants to be a part of the committee, my lord. My lord, on the last occasion, my lord, in the course of the hearing, my lord, the constitution of the Garikhana Masjid Committee was produced, my lord. So there is no such provision for control of the school, my lord. So, my lord, a prayer was made. So perhaps private respondent would be, I think there was a direction, my lord, to file bring the constitutional record by way of an affidavit.
My lord, lordship come to order dated 9/8/2023.
Yes.
Lordship, para 2. In the course of hearing, the issue of the authority of the petitioners committee over the management of the said Madrasa Himayatul LP School Shillong has arisen for consideration, and accordingly to further clarify the position, the respective parties have made a prayer for filing of relevant documents in this regard. Now, my lord, here, in this aspect, my lord, I won't be filing any documents because I'll be relying on whatever documents are previously lodged.
My lord,
It's up to the respondent.
What about the
respondent will, my lord, on the last occasion, if I remember. My lord.
who are you?
I'm for respondent number 4.
The managing committee.
You are the managing
The
committee.
current managing
Okay,
committee, my lord.
So you say that the masjid committee has no control over you,
Your Lordship.
and they would say otherwise.
My lord.
This was the argument of the state also, my lord.
So the constitution is not on record here.
No, my lord, it was never produced on record, but in the course of the hearing, my lord, this constitution
Okay.
was taken into account, my lord, but however, since this is not before this honorable court,
You are the masjid committee.
My lord.
So what prevents you from bringing on record the constitution or producing it today?
No, my lord. The only thing is that, my lord,
If you are afraid that it will be against you.
No, my lord, nothing as such.
Everything it has to be transparent. if that is what is required,
Well, on the last, that's why my lord was very clear that parties, anyone, my lord.
yes, anyone. That's what. But it would be proper to have to have come
The
from
only
you.
difficulty for me is that since the petitioner is present at our station or not, since he is undergoing treatment, so I will be filing, and as such I have got instructions that will be relying on the documents. Please before your lordship.
However, my lord, the document is available with the private respondents. My lord.
If they want to file, my lord, let them file.
So you will file.
I'll file it, Your Lordship.
No, no, today I'll place my bullet point on my points of argument.
No, this matter can only proceed after the filing of this, my lord.
If any clarification is required.
Because, my lord, on the last occasion there was an at-length hearing, my lord.
I remember.
It went on for quite some time, my lord. Now at the fag end, my lord, this aspect came, my lord, and therefore there was the direction from this honorable court. Therefore, my lord, even the order is very clear for clarification. So, my lord, proceeding with the hearing without this document, it will require another hearing, my lord, another day. It will be a piecemeal basis, my lord. Let the document be filed and let the hearing be concluded, my lord.
You file the document, do it, and then we'll take up the matter on Monday. Then.
Monday is okay.
It can come on Wednesday, Your Lordship.
Mr. Counsel, yes, you are CTC or CTT?
CCT, my lord.
CCT, see? Ini wrong you ni. CCT, sama Land Counsel for the petitioner has submitted that the petitioner has no documents relevant to the case to be produced and would rely on whatever has been submitted before this court. The respondent number 4, managing committee, however, has submitted to its counsel that they may be allowed to file any relevant document, including the constitution of the Karikhana Masjid Committee. On premier, the same salon, the respondent is directed to do so. Respondent number 4 is directed to do so within the next date fix, as submitted as prayed for by the parties. This is matter on 30th for the hearing.
Item number 4.
May I please, Lordship? My Lord was pleased to give me a time for file a rejoinder, my Lord.
Oh,
that's matter pertaining
that,
ACP and MSP.
No, I mean the affidavit in opposition was given to you without an annexures.
Yes.
So you have received.
I have received, my Lord. So, my Lord, I require, since the petitioner is in Manipur, my Lord, for the petition, so we will be filing. We require 3 weeks.
Mr. Arjal, Leonard, counsel for the petitioner, has submitted that pursuant to this court's order dated 9/8/2023, copy the
copy of
complete set of the affidavit in opposition filed by the respondent Union of India has been received. It is, however, prayed that some time may be allowed for the rejoinder to be filed. As prayed for, the prayers allowed. As prayed for, this is matter after 2 weeks.
Item number 5.
My lord, same, my lord.
Same.
Same. Connecting.
Same order.
Item number 7.
In this matter, this is the petitioner and the respondent number 2 have executed some work contract in the year 2008. Now we have raised certain bills. I am the contractor. I have raised certain bills against NBCC, who's the employer. Now those bills were not paid by the employer. Now I have approached the Facilitation Council under the MSME Act, Medium Small Scale Industries. Now those proceedings have been initiated. Now against those proceedings, Your Lordship, the petitioner has approached this court by way of filing this writ petition. There are 2 writ petitions filed because there are 2 tender contracts. Now, in the meanwhile, Your Lordship, what has happened is the petitioner here now has released those bills to the respondent number 2. So, in that view of the matter, Your Lordship, my grievance has already been met out by the petitioner here.
Nothing remains.
Nothing remains in this matter.
Yes, Mr.
The problem here is I have come by way of 227, my lord. So the original complaint which was filed by them before the council, that has to be withdrawn. This will die its own natural death.
So we'll wait for.
We'll have to wait for him to withdraw.
Whose death first?
His death first, my lord. I'm the subsequent. I'm the offshoot, my lord. I will.
Yes, since he has
Yes,
stated at the bar that his grievance has been
correct, my lord.
Attended to.
Yes, but those proceedings have to go, my lord.
So you take steps
Formally.
then.
I'll take steps before the council.
Concern authority.
That liberty may be granted.
And then whatever you see the outcome of the steps taken, bring it before this court. And matter will.
Yes, my lord. This will become infectious.
So how long?
2 weeks, Lordship. After 2 weeks, Lordship.
On play made by the respondent number. Your respondent number? 2.
Number 2, Lordship.
Matters adjourned to enable the respondent number 2 to take necessary steps. F9. This is matter to 2 weeks.
Hello,
7 and 8.
7 and 8.
7 and 8.
Item number 9.
But here we require some more time to file additional affidavit. But what had happened, my lord, on the last occasion, my lord, we had got the inquiry report regarding the findings, my lord. But however, my lord, this honorable court directed, because there were some submissions made, my lord. So there was a direction that an affidavit be filed, my lord. So I'll require some more time, my lord.
What is this matter about?
With regard to compensation of the land ownership.
Land compensation?
Yes, my lord, what had happened is that some job was given on the basis of the land, my lord, that matter. So my lord had directed that we file an additional affidavit.
In lieu of the compensation?
Yes, my lord. So that is the matter.
But in spite of that, they have come.
No, Your Worship, actually they acquired 2 land ownership. For one land we executed a deed, and in lieu of that
you were given jobs.
Yes, given job. But in
That is
other
not-
in
that is
the other land
factually
they were not
incorrect.
given us a compensation.
Because for whatever land, that is factually incorrect. We have clear evidence that is factually incorrect. Whatever land was acquired, 3 lands were acquired, my lord. For all the 3 jobs were given.
Okay. Have you brought that in your affidavit in opposition?
In the earlier affidavit, it was not there, my lord. There was certain, my lord, what had happened is that initial round when we filed the affidavit, my lord, certain confusion arose with regard to a certain annexure, my lord. Then, because there was a confusion with the annexure, this honorable court had directed that you please clarify this fact. So thereafter, my lord, for clarifying the whole aspect, my lord, a report was prepared. My lord, that was before this honorable court on the last date, my lord. However, this honorable court said that you please file affidavit with whatever facts. Because the basic thing was that whether this is stated in your earlier affidavit, so we stated it's not there, my lord. So that is why permission was granted, my lord.
So you are to come with an additional affidavit.
Yes, yes, my lord.
Bring the record, Your Lordship.
You have not been able to do it today.
Today will not be possible, my lord. I'll pray for because the officer is also from Garu Hills, my lord. So I'll pray for 2 weeks within which we'll file it, my lord.
Mr. KP Bhattacharjee GA has submitted that the additional affidavit to bring on record certain documents and clarification,
as well as factual aspects. Yes.
and clarification on this factual aspect of the matter.
Yes.
Would not be filed today and has prayed for some time for the same. On the prayer not be objected to by the petitioner, the same is allowed. Let the said affidavit be additional affidavit be filed within the next date fix. This is not up to 2 weeks.
All right. All right.
Item number 11.
May please, Lordship. This matter pertains to the delay payment of gratuity.
Gratuity?
Delay payment of the interest on the gratuity.
Interest on gratuity.
Gratuity. So far this matter is concerned, madam.
Who are you?
I am the petitioner.
You are the petitioner.
In fact, there were 95 petitioners. In fact, 95 petitioners. They were the employee of the McAfee.
Oh, again.
This matter, there was a series of litigation and intra-court appeal. The matter up to Apex Court. In the Apex Court, ultimately passed an order that the petitioners are entitled to payment of gratuity. But nevertheless, it was a case where it took more than 15 years. Now the fact remains that we are claiming the interest
for those 15 years.
Yeah, madam. We're claiming the interest.
Have you received the gratuity?
Yeah, we have received it. We have received the gratuity amount.
When?
We have received the gratuity
15 years ago?
Madam?
15 years ago?
Yeah, since we were made to retire in the year 2004.
So,
on the basis of the VRS scheme, thereafter, after our retirement, since they were on the basis of the scheme, which there were some grey areas,
if I recall correctly from the other case, it involves just that golden handshake.
Yes. Madam is correct. They go on the basis of the golden handshake. It was mooted out on the basis of that, and then subsequently, this matter was laid to rest after the matter had travelled to the Apex Court, and the Apex Court had they had submitted that we are entitled to payment of gratuity. Now we have come here for payment of the interest on the gratuity. Now, Malad, since the law is also very clear with regard to the Payment of Gratuity Act. Now, our only contention here is basically that so far the Gratuity Act is concerned, Payment of Gratuity Act 1972, Section 7 clearly stipulates the interest part. Section 7, Clause 3A stipulates the
payment of interest.
Section 7 and subclause 3A.
Capital A.
Yes, ma'am. If I may be allowed to read.
Please.
If the amount of gratuity payable under the subsection 3 is not paid by the employer within a period specified in the subsection 3, the employer shall pay from the date on which the gratuity becomes payable to the date on which, if it is paid, simple interest at the rate not exceeding the rate notified by the central government from time to time for repayment of long-term deposit as the government may or by notification specify. And there is a proviso also, provided that no such interest shall be paid if the delay in the payment is due to the fault of the employee, and the employer has obtained permission in writing from the controlling authority for the delay payment on this ground. My lord, since the statute itself provides for payment of interest, we are here for asking for the interest on the delay payment of gratuity. Now, now the vital questions that has come up is this, that the gratuity, it is on the basis of the amount of gratuity that was wrongfully withheld for no justifiable reasons, in consequence of which resulted in a series of litigation till the matter traveled up to the apex court. Now, my lord, they had taken a plea of laches. The question of plea of laches cannot be raised by them because they had defaulted in the performance of the duty in not paying their statutory due when it became due. Now, this interest also, it is a case that it is an enforcement of an incident of the same right. So far the interest is concerned, it is the enforcement of an incident of the same right, that is the right to our right to claim for the gratuity which has already been paid. So the interest part is it is an incident which has been clearly stipulated in the Payment of Gratuity Act, as I had just read over, that we are entitled to the interest. Now again, now fact remains that if the question here is this, that now it would be in the delay that has been occasioned was that because of the series of litigation. They ought to have been, the gratuity amount ought to have been paid at the first instance, where on the basis of which the golden handshake scheme, which provided that the statutory payment of dues for leave encashment gratuity shall be paid. It is, and it was, they ought to have paid at that point of time when the petitions were made to retire compulsory on the basis of the scheme. But nevertheless, this amount was never paid, which resulted in the series of litigation.
You mean the interest or the gratuity?
Interest. Now we are
ought to be
at that point. My lord, the only thing is this: at that point of time, when the payment of gratuity was due, they ought to have been paid the gratuity amount.
Yeah,
so the question of interest wouldn't have been
exactly,
taken.
exactly.
Now the question of interest has come up here. It is
because eventually, when the gratuity was paid to you, it was after a delayed period.
Yes, after a delayed period. So when the law stipulates for payment of interest, and that delay is basically occasioned due to the fault on the respondent employer. So now the burden lies upon them to show that they were not guilty of any culpable delay.
So we are practically on the proviso now.
Proviso. Yeah. So my only the submission is that the burden would lie upon them to show that they were not guilty of any culpable delay, and if they are unable to discharge the burden to satisfy this court, then my only prayer is that direction to pay the interest would invariably lie upon them to pay.
Yes, Mr. Yubin.
My lord, in a normal rule where the petitioners are supposed to establish their case, but here the burden shifts to me as well. But however, my lord, I would like to answer this, whether there was a delay in payment of the gratuity, and if that delay had occasioned on our part, then we are liable to pay interest. But the question here is now, when did the gratuity become payable, and whether there was a delay or not? Because the Act proviso section 7 subsection 3 provides section 3A, my lord. This talks about under a normal circumstances, my lord. Here, rightly been pointed out by my learned senior, that the question, because these are the employees, 95, 100, 110 employees who had accepted the voluntary retirement scheme. My lord will recollect that there was a model scheme under which it has to be worked out. Modalities. We did not, because our service rules did not provide gratuity, therefore we did not include in the while formulating how much is to pay, or what are to be included in the golden handshake scheme. We did not include. Now after they received, the question came up whether gratuity is whether the Gratuity Act is applicable to MEPOFET or not, PSU or PSC or not. This question, my lord, this question was all along when contested, my lord. It was contested before the learned single judge. It was contested before the learned division bench. It was finally it was contested before the Supreme Court, my lord. In the Supreme Court, my lord, as I would like to reiterate, my lord, in the Supreme Court we took a very conscious decision and says that we will pay them the gratuity. But that was not in judgment in rem. That was judgment in personam to only those people who have taken the VRS. Now, my lord, in that judgment, my lord, when we went for the SLP, we said we will pay them the gratuity. We'll pay them the gratuity to the people who have accepted the VRS. We will not fight anymore. Therefore, enough for 14 years, 15 years. So, as an employer, we will show, as a model employer, we will pay them. And this order came to be passed by the Supreme Court, page 68 of the writ petition, my lord. This will decide, my lord, now. Annexure 3, my lord, is a copy of the writ petition.
Yes.
Now, may I read, my lord? Mr. Vijay Hansel, learned counsel for appearing for the petition, states that the petitioner company shall pay the amount of gratuity to the persons who have sought voluntary retirement under the voluntary retirement scheme or golden handshake scheme. The statement is recorded. Means who? Means this 95%. We said we will pay them. We should. And then my lord, what is that? Renjoined affidavit. Now next page 69, my lord. Last line, my lord. Yes. Because in the middle it talks about leave encashment. Last line. However, the amount of gratuity shall be paid to the respondents within a period of 1 month from today. From today, the day that is on 2nd April 2018. Within 1 month, my lord, we got a fund, we have paid to them. They have received. They have received. The court, Supreme Court says that within 1 month you go and pay them. We pay to them. So now the question of interest, the question of delay. Where is the question of delay in payment of the gratuity, my lord? And my lord, in the first place itself, this is where I would say that we have not delayed, my lord. And the claim at this stage, they cannot claim for the interest, because when we have not delayed, we have not faulted. Because all along, my lord, there was a challenge. It is them who has been challenging. And finally, in the Supreme Court, we said, we give undertaking, we will pay. The court said, then you shall. The court directed us, you shall pay within 1 month. We complied with the directions. If they feel that we have not complied with direction, the appropriate remedy would be them to file a contempt against us in the Supreme Court. Not coming with a fresh case to file for an interest, saying that we have delayed in the payment of the gratuity, my lord. Therefore, my lord, the claim has no legs to stand. It's not sustainable, my lord. And second part also, my lord, why I say the delay, because I wouldn't like to touch that part, but then since my learned senior has raised the issue of delay, my lord, when we file a petition, you have to claim entire thing in whole, my lord. That is the normal pleadings, my lord. Otherwise, then it becomes a multiplicity of cases, my lord. 2004, 2007, they have been fighting this case, my lord. I can show, my lord, in my writ petitions that in not even one occasion, none of the prayers was for the interest. They have never claimed for the interest right from day one. Only after we have paid to them the good amount, they thought that they can also get interest. Therefore, my lord, that they are also, my lord, number one, when they claim, they should have claimed in whole, if at all some arguable case to be built out. They have never claimed. They were silent, completely silent. Single judge, they were silent. Division bench, they were silent. Supreme Court, they were silent. Before that, before the controlling authority also, they were silent. Because this, before coming to the Honorable High Court, it went to the controlling authority. Controlling authority said, Macofed is a society, therefore payment of gratuity is not applicable to Macofed. This is what the controlling authority said. That's challenge. That order was being challenged. Therefore, my lord, in my humble submissions, my lord, if the only question is that, if they're raising that we have delayed in payment of gratuity, we have not delayed in the payment of gratuity. If they feel that we have delayed, then they could have filed a contempt case against us. Why they did not file a contempt case against us? Because they knew that there was no delay. So this is like, my lord, it's a chance petition, thinking that somewhere they may get there's a chance petition. I said I would elaborate much. I hope my senior might.
State has got nothing to do with
it. But adopting his submission. But the sources, money comes from them. So they cannot say, oh, that nothing. Yes,
but that is a different procedure altogether.
My lord.
My lord, I'd just like to supply, my lord, the last part of the order that has, where it has order passed by the Apex Court is said that to be paid within 1 month. My lord, this is an order passed by the Apex Court to be paid within 1 month, which they have complied in order to avoid the contempt. But the right to accrue for payment, of gratuity, it accrued since 2004 at the time when they were made to retire. Now the series of litigation which took place, this series of litigation, the question I had raised, my lord, that who is guilty of any culpable delay? The delay that has been attributed, we wouldn't have claimed for any interest at all. That is an ancillary to that. We wouldn't have the matter wouldn't have come before the court for any litigation had they complied. The matter went before the controlling authority, and thereafter, on the basis of that, series of writ petitions were filed. We had to contest, we had to exert our right to get through the court. Now, fact remains that the delay that has been occasioned in the litigation is basically, and under all circumstances, is because of the fact that they had failed to comply in paying the gratuity on time, which they ought to have paid. And because of this series of litigation, and this series of litigation is attributed to the culpability is attributed to them. And that is why, had the order not been there, this wouldn't have been, they wouldn't have, it would have been dismissed, matter would have been gone. But so far the payment of gratuity is concerned within 1 month. This is basically on the basis of the order of the court, order of the Apex Court. But what about the delay that was attributed? This delay, my question is this, the delay has been attributed to the fact because of the respondent, where they have failed to comply in the cabinet memorandum. My lord, I just, because we are basically here only related to the matter related to the interest on the delay payment of the gratuity. Now, since my learned friend has raised the question that in their affidavit at page 34, this is just a reference that page 31, para 4, page 31. How did the entire matter emanated from which led to the series of litigation?
Yes.
Para 4. Only the para 4, if I would read. In our state, some of the state PSC have already been more or less regular defaulters in matters of salary payment, and it is well known to the employees that these PSC are deeply in the red. It may be worthwhile for the state to examine the idea of voluntary retirement, perhaps with the condition that all the dues would be paid in lump sum amount within few days of their relinquishing the office, not piecemeal. If the state can ensure this, there is high probability that the response to this scheme would be good. As far as the other statutory payment like provident fund, gratuity, leave encashment, etc., these have to be paid within a stipulated frame of time. I'm stopped here because why? It is on the basis of this. They have clearly mentioned that gratuity would be paid to us, and that later on.
Oh, this is a sweeping. This is a sweeping statement.
Yes, yeah, sweeping statement. But it is on the basis of that this amount would be paid to us. Then, because of this, thereafter the matter had also proceeded to the controlling authority, and that led to a series of litigation. Had they complied, matter would have ended. So
you see, Mr. Khan, I think initially the issue was whether you are entitled to gratuity or not.
Yes, absolutely. That issue is laid to rest.
You see, that issue was German to the the litigation thereafter. So it has not been decided, or rather it was contested by the respondent that you are not entitled to gratuity. Like you said, eventually the matter traveled to the apex court, and in the apex court this issue was not decided. Not decided, in as much as it was a concession made by them that okay, we will give you gratuity.
Yes.
So it was a like a off the cuff statement, not really delving into the issue, or rather the discussion whether you are entitled or not, since when you are entitled. All those matters have not been decided, and the Supreme Court, if I can understand the the order correctly, says yes, you have said so, do it. So now what if I can understand correctly, what they would interpret the orders of the Supreme Court to be is that you are entitled to gratuity within 1 month from the day of the order. So that is where that should be the position as far as gratuity is concerned, payment of gratuity is concerned. Thereafter, if there is a delay, then interest would have been would have accrued.
But my contention is that
I understand.
Yeah,
my contention is that because of the act says so. So
yes,
you are entitled.
So because of the act says so, I am entitled. But if let us assume if it was a case that even after the order of the apex court, they had failed to comply for payment of the gratuity, the interest would accrue.
Yes.
That was on the basis.
Yes.
But nevertheless, now the question is that the delay that has been occasioned for so many years in the payment of gratuity, we are claiming the interest on the basis that. Well, to that effect, there are a series of judgments are also there. I would like to supplement that judgment. I can supplement those judgments. Maybe this matter can come up, because this is the first occasion this matter has come up before this honorable court. So I can supplement those judgments. There can be a.
Yes, I think that will be.
I can.
If you can clarify that, aspect of the matter.
Yes.
I can clarify.
Because the question is, very legal question is, can't pendency of an issue in the court be contributable as a delay and laches, or a delay of the case or not? That is the question. That is, if it's not, then we are not bound.
If you can take the analogy of the Limitation Act.
Yes.
Limitation.
So there, you see, there also that if a matter is pending in court, that should not be considered as delay.
As a delay.
For the purpose of Limitation Act.
Limitation Act, yes.
So
that is a real issue here, actually. What I feel, my lord.
Because, my lord, the proviso of the interest also provides that interest cannot be paid if there is a delay. If there is a delay in the payment due to the fault of the employee. If we are at fault,
of course,
my lord, if we are at fault, We have, it is there. The culpability lies on them.
You are not at fault.
My lord.
They are not at fault. It is because of the process.
My lord.
You see, it is because of the process.
My only thing is that had they complied at the first instance,
That
this
is
wouldn't
the
happen.
thing, see,
But that is the thing that.
See, now we cannot go back to that because
My
that,
lord, I am not
that is
going to
exactly
that.
the issue that
Yes.
you have agitated right from the
From
from the High Court.
My lord.
So that matter has been settled.
That matter has been settled. So my only contention before this honorable court is that I am entitled to the payment of interest on the delayed payment of the gratuity from the.
So now
I
you qualify on
My lord.
what is delay? What does it? How does it? It fits into the scheme of thing here.
My lord.
And
There,
then,
so there
your
are
authorities
many
will be-
judgments on it. Even if interest is not claimed, I'm entitled to interest.
And then what you can do, Mr. Khan, it would be better if you can just give a bullet point of your submission.
My lord, along with judgments.
Just along
Yes,
with judgments.
along with the
Similarly,
judgments.
Mr. Yovin,
I'll do
you
the
can do
same
that.
thing, my lord. My lord, let my senior submit first, and I'll in a rebuttal form. I'll give my.
You can do one thing. I'll push this matter to 2 weeks.
2 weeks, my lord.
In the meantime,
My lord.
within the 2 weeks, you prepare your written argument and the more importantly the authorities and give an advance copy.
Yes, yes.
Then within that 2 weeks time, he can also file.
Yes,
So that it will not delay the matter.
My lord, then in that case, let it be 3 weeks. Maybe some.
Heard the counsel of the parties. However, before the matter is concluded, the learned counsel for the petitioner has submitted that he may be allowed to cite certain relevant authorities in this regard. As prayed for, the parties are to file the written synopsis of their argument along with the authorities relied upon. This is matter for 3 weeks.
3 weeks. All right.
Item number 12.
Lordship, I'm appearing on behalf of B. Pathak. B. Pathak is on legs, Lordship, in another court, so I'm praying for an adjournment today.
You are for petitioner?
Yes, Lordship.
Yes, Dr. Muziga, what is this matter about?
Well, here what happened, my lord, around 2016 or 17, many of the Assam Rifle personnel were compulsorily retired for low medical category, my lord.
Okay.
For obesity, some were suffering from blood pressure. And that was done under the service review system on completion of 30 years of service. They assess whether medically fit or not.
That rule 26?
Yes, my lord.
Could be.
Yes, my lord. So, my lord, they came before this honorable court, my lord. Justice at that point of time dismissed all the writ petitions, my lord, saying that physical fitness is very important for post personnel. And then, when Justice Sen disposed of the matter, there was around 79 writ petitions were disposed of by a common order, my lord. So, all the dismissal was upheld, my lord. Assam Rifle dismissed them, and that was upheld by a single judge of this honorable court, my lord. Only 17 or 20 of them, they went on appeal, my lord. That the appeal was disposed of by Justice Maheshwari, my lord, sitting with. And Justice Maheshwari remanded back the matter. While remanding back the matter, Justice Maheshwari said only for the petitioners, my lord.
Court petition, those 71.
Those who filed appeal, only we call them. And subsequently, your lordship disposed of the matter, your lordship allowed the writ petitions, my lord, granting them relief, that you proceed under the proper rules. Now, these are the people, my lord, who did not file appeal at that point of time.
So they are fence sitters?
They're fence sitters, my lord. Our case is that their res judicata will apply to them, my lord.
So we'll hear the matter.
While remanding back the matter with the division bench led by Justice Maheshwari, clearly said only vis-a-vis the appellants who filed the appeal.
They may have a separate cause of action, or we know.
At this stage, my lord.
That issue, so the issue of delay and latches will be looked into.
My lord.
So how long, miss? Tell me.
Lordship, next week, Lordship.
2 weeks, my lord.
2 weeks. He asked for 2 weeks. Are you okay with 2 weeks?
Okay, Lordship. Yes, Lordship, I'm okay with 2 weeks.
On payment by the parties, this is matter up to 2 weeks.
Obliged, Lordship.
Item number 13.
Wait, please, Your Lordship. Lordship, the case of the petitioner is that he was terminated firstly on the 16/12/2015, thereafter followed by an inquiry, and upon completion of the inquiry he was reinstated, and upon reinstatement, Your Lordship, for the second time he was terminated again. So, Lordship, upon termination there were certain agreements that were executed between the petitioner and the school respondent.
You're a teacher?
I'm a teacher. So, Your Lordship, upon my first termination and upon reappointment, I was demoted from my post. So, Your Lordship,
Mr. Yubin, you are appearing for?
My lord, I'm appearing for the respondent number 3, 4 and 5, my lord. 3, 4 and 5, my lord.
So who's appearing for the state?
States, my lord, earlier.
Mr. Abraham, he appeared earlier.
So if he's not here, then how will he respond?
Yes, Your Lordship.
Let it.
Always, you see, whenever the matter is called up, always ensure that all the parties are in attendance.
Yes,
Otherwise, hearing you, they may come and say, you know, we have not heard
Yes.
whatever you to respond to your.
Lordship, if it will the matter come after.
Mr. Abraham, he was not here.
Mr. Abraham, I didn't see him in the party.
This party should be responsible.
Government.
Small matter like this, then we have to wait for another day. So,
let the matter come after a week.
You are for the.
I'm for the
committee?
MC also, and the Dolba, because it's a Dolba Shnong's school, madam. So I'm representing them.
Could be anybody's school. Government aided.
Yes, madam. Government.
On payment by the parties. This is matter after 2 weeks.
Aliyo batch.
Item number 14.
So, Mr. Pandit. Yes, Mr. Pandit. You have.
Lordship, the last
you have
occasion.
filed.
Yes, Lordship.
Have you received copies?
To this CBI, we have served the copy, my lord. To the newly implicated party sought to be implicated, we have not served the copy.
Yes, that's what you said. You have not received copy of this. Give me.
Lordship.
First, we'll allow the implement.
Lordship.
Then copy will be given to them.
Lordship.
The implement as the seeking is implement as respondent, my lord.
In item number 15 and 16, so the lordship has passed an order in all the matters.
Oh. So, then as far as 13 and 14 is concerned, you are not required to be there.
No, you're challenging only the order of transport, not even the charge. Okay. The other aspect, the other petition, challenge the order, wherein the trial has been postponed.
Oh, postpone on your account.
In that, we have filed, my lord.
Yes.
In that, where, my lord, the charge
Naturally, they have to be.
segregated,
They have
made
to.
in the
They
party,
have to
my lord.
respond.
In the other petitions, my lord, we have not made them as a party, my lord. In the quashing, we have not made them party.
Okay, so in that case, then as far as 14 and 15 is concerned, where they are not required.
14 and 17.
14 and 17.
Become so confusing now. So many cases.
May I just in my case, item number it's case number 70, lordship. It's a criminal petition number 70. 16.
Yes.
What is exactly?
So, Mr. Panthi,
Lordship.
you are appearing in all these cases, isn't it?
Lordship, Lordship.
In 14, 15 also.
14 under instructions today I am appearing, my lord.
Oh, okay.
And 16, 17, my lord.
So 14 and 15, I believe. See now again, I think Mr. Khurshid have only made his
Lordship.
submission, but I think he has to refresh this quote.
Refresh, my lord.
Whatever the case may be, this is only for reply by the CBI.
14, 15 minutes.
14, 15. You are not in this.
In 15, you have challenged that or the one?
Okay, good. So in 15 you,
Yes, ma'am.
in
So
14, in 14 you are not there. In 15 you are there.
In case, my lord,
I'm not able to understand.
Actually,
So
my lord,
you just have to picture one thing. There are three accused person. He is the accused person who has been let off by the court, apparently on
health ground,
health
medical
ground,
ground.
whatever the case may be. So two remain. Two remain. Now one of the accused person has come before this court against the trials court order. So that's it. That's number 14.
Lordship.
Against the framing of charge, isn't it?
Framing charge.
14 is against framing of charge, 15 is against that letting of that.
separating
other
the-
accused.
segregating the charges.
No, 16 is
Charges.
16 is I don't understand now.
So 16 is the other, the accused number 2 who has come
Lordship.
on similar grounds, as was there in 15.
I just check the prayer in 16 because that name confusing, madam.
23.
Now here is opposite, my lord. 16 is letting off the other accused, my lord.
Yes.
And 17 is quashing the charges.
Okay. So see, so 17,
14 and 17 are
14 and 17 are akin.
my lord. 15 and 16 are.
So 15 and 16 are okay, where he will be involved. So you will not be involved in 14 and 17.
So 15, 16, you
No.
14 and 17, no.
So miscase has been filed in 15 and 16.
No, sir. Yes, sir. 14 and 16, 14 and 17.
This case has been filed on 14, 15, 16. My lord, since your lordship already passed an order.
But my lord, in my case,
I'm not able to.
Your lordship already passed an order.
may I just make a brief submission, lordship?
I can get the picture now.
Yeah, my lord has got it. Basically, my lord, two petitions have been filed. One, my lord, is for quashing. One for segregating the trial, lordship.
Yes.
The trial court, my lord, had segregated the trial
Yes.
by keeping the trial against the A3 in abeyance.
Yes.
Had proceeded with the trial against 1 and 2, lordship.
Yes.
So that order has been challenged. In that, since it is, my lord, directly against the A3,
Yes.
so we have implemented A3 as a party, lordship.
Fine.
And the quashing was between the court and the, my lord, the accused persons.
Yes.
In that, we have not made a party order.
So Surya not.
Yes, lordship.
36. I think they also made some mistake, my lord. 36 is question, right? 36 question. So 36 is question. Why they are filing in criminal petition number 36 to implement then?
36.
You mentioned it. Criminal petition number 36 or 23.
Oh, 36 is not for only for against the framing of charge.
Lordship.
That's 36 is item number 14.
14.
My lord, if we leave aside the cause list number, my lord, criminal petition number 36 is by Amperin Lingdo for quashing the charges, my lord.
Oh, that's it.
There, the
A3 is not required to be
not
there.
required, but they filed an application for implementing in 36, my lord.
Yeah, because I think because perhaps now the fault lies with the court most probably. He says that a blanket order was passed or a common order was passed. Is it so?
36, my lord, 36 was basically, my lord, what had happened. In fact, we had to file an application.
Let's do one thing. We'll clarify the situation now to say that as far as 36 is concerned, the A3 is not required to be implemented. If any application has been filed, that would be disposed of. Have you filed any application in 36? You have not.
We have been added as an.
Okay, no, we have not filed. So then the matter ends there.
But
In 36, they have filed, my lord.
36.
He says no.
I don't know.
You say yes.
The application they've given you a copy, I don't know. What
This,
is it?
these are.
Yes, the 16.
That's in 36.
This filed by A1 Lordship. It's filed by A1.
Yes, filed by A1.
Yes.
Filed by A1,
Yes,
but
right.
in pleading A3.
Lordship, yes, this way. This way.
Exactly.
In both
So
the
now
cases
we'll correct that.
We'll correct
To say that A3 is not required to be pleaded here.
Lordship. That
Okay. So that is one. Then we'll go on to the next.
Lordship.
Otherwise it becomes confusing.
I'm still not.
Tapas, heard Lana counsel the parties.
My lord, rather, would I pray, my lord? I'll figure out, I'll sit with CBI and them, my friends also, my lord. And we make a chart and where what is filed, my lord.
That'll be better.
It's really.
I think, but it's understood now. It's understood.
I have not understood, my lord.
So come back tomorrow?
Tomorrow, Monday, Tuesday.
To clarify this issue, my lord, in which what hasn't filed
Okay,
and what is
as Dr. Musik has said, you sit down and just note down.
We'll make a table that
and
what is which case number is
whatever
what.
order is required to be modified with this court, that will be done.
That will be done.
On prayer made by the parties, this is matter of 1 week.
Deeply.
Sit.